Hello, my wonderful friends. Sally the Seeker here. It's been nearly a week, I know. But I'm finally getting part 2 up for you guys. I am so sorry for the delay. I just said this because I'm not sure if some of y'all just follow Darrell Brooks or Chad Dorman, whom I'm also following, or Sarah Boone, or all three. So it might be a redundant message on each of these, but I just want to make sure I get everybody covered. I apologize for being behind in the comments. I have been reading them. But I haven't even given the hearts out yet to let you know I've read them or responded. And I apologize for that. Please know, though, that even when I get behind, your comments are very important to me, and I love reading them. I just might be a little more delayed than usual, or when I say I have, or when I say I'm going to do it. I always think, I guess I'm an optimist in the regard that I always think I can do things maybe more or faster than it ends up being. But then I guess that thing called life happens. I started back to school and getting back into the swing of that. And though I love the classroom, the kids, we have twice as many in the classroom as we did last year. And the first few weeks is always like an adjustment from the summer. And all of us are just exhausted. So I come home exhausted. So I just haven't been able to do as much as I would like to do. Hopefully I will get past this and make the adjustment sooner but than later. And plus, we've had this horrendous heat in Florida that just wears you out as well. But I do want you to know that how much I love and appreciate you all watching, commenting, subscribing. And even if I'm slow getting to the comments, it doesn't mean that I don't care. I promise you that. I truly appreciate them. But, hey, here I am, doing the best I can. But I wanted to, I know, well, first of all, if you haven't seen part 1 of this, I would really highly recommend you go to watch that first. I mean, especially if you haven't watched the trial at all. And if you have watched all the trial, maybe you're okay to skip to part 2. I'm just saying I kind of had to break it up because it's so long, because, you know, Brooks takes so long, and, you know. But in the prior video, this is when when the prosecution questions Detective Casey for the second and final time, and that's when all the questions about leading to the playing of his horrendously cringe rap video. Thank God they didn't turn the sound on for. But because of the fact that Brooks was questioning Detective Casey's, you know, ability to recognize him, because the photo that probably most of us have already seen, that they got the still photo they took from the video and put it up as an exhibit, was at the end, and it showed Darrell and the other fellow that was rapping with him. Their backs were to the camera, but it did show Mama's red SUV with the license plate number, you know, was the weapon. I mean, we can say it now because we all know it was. Everything's, you know, that he used during the parade attack. Yes, it was a horrendous attack. But even though Detective Casey told Darrell multiple times that he was able to identify him from that still photo because he watched the entire video, but being the woodpecker and the petrified forest that Brooks is, he hammered and hammered away. And so that's when we get to see the storm erupt, because Opper, I know somebody else calls her Opper the Chopper, and she really is. She is quite honestly my hero, because I think she is the one woman that even though he acts like, you know, he's all big and bad, that he fears the most, because she really, and you'll hear me say it, she's fearless. She tells him exactly what she thinks. She makes no apologies, and I love it about her. So what I'm going to do is, since the second video kind of cut off in the midstream, I'm going to replay just a little bit of it so it can kind of refresh your memory and make more sense as I post the second, video, where things really get crazy. So, and also, I had said, and go ahead and do this in this one as well. I said I was going to drink my Sprite every time Darrell puts his head up to seek the ceiling. Either he's looking at Post-its that give him sage advice, or his guardian angel, or his demon, whatever. We don't know what the hell he's looking at. But so, now I might have miscounted, but I counted about 30 times that he did this in the prior video and this one. And I don't know, I might have given an extra point if the head was up a little bit lower, because sometimes you know how he'll stare like a middle school brat. Would it be fair to say I took a lot of sips of Sprite for the 30 times Brooks threw his head up in the air? I don't know. I might have had to go to a second Sprite. I think I probably took more gulps than sips. But yes, it would be very fair to say that I did do that. Also, it would be fair to note that Brooks never got got an answer to his burning question in the last video as to, who is this guy? Who's the guy in the blue suit? He's there every time. Nobody knows who he is. The jury needs to know. That was pretty funny. You know, if Brooks wasn't a murderous idiot, he would probably be a great comedian. But he's none of that. So at this time, I am going to play just a little bit of the last part of part 1 so that we can flow more evenly into part 2. So sit back, get your popcorn, your favorite snack, your favorite drink, your favorite thing to inhale, whatever, and enjoy. Let's just call it Darrell Brooks, the comedy, the joke, the idiot. This is so ridiculous.
I'll answer yes if that helps.
Such a waste of time.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in the investigation that sits with the prosecution?
Talking about this case or any case?
This particular case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution? in reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
Oh my
Objection
gosh.
to irrelevance, Your Honor. Sustained.
I just want to know his role.
Sustained.
He's
Next
your
question,
For the
please.
substantive.
Not relevant.
He's been in the courtroom the whole trial. How is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is.
He's the bouncer of the courtroom. He's going to take your ass out when you misbehave. Excuse me. I mean, I'll be honest, I kind of didn't know who he was at first either, but clearly he's a detective. I know that. But, I mean, such a stupid question. None of these are helping. Nothing's helping him.
That should be known.
Please.
Somebody sits
It's
at
not
that
relevant to
table.
the issues that the jury needs.
Oh, he doesn't have anybody sit behind him at his table. He's leaving out Mr. Bailiff. Who does he want at his... Who's going to sit at his damn table?
Determine. Next question, sir.
Is it asking or telling?
Oh, man. I cannot stand him. Have y'all heard me say that before? Just, he needs to... You know, and the jury is what...
Asking.
See, and he thinks he's so cool for the jury. Wow.
No, the other one wouldn't tell.
Wow.
Um,
Do
Wow.
you have a question, sir?
yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will.
You know, he's done that type of thing to her before when she said to go on with the question. That same thing. I'm getting to it if you'll let me. You know, the jury, he thinks the jury, I can't even, the jury
So seeing as how
is hating this.
sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Oh my gosh.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection.
Grounds.
Legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You are
Move to
aware of
strike.
that, right?
Go ahead, Attorney Apper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a legal conclusion in any way.
The court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the stated, also as a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling. And would like a legal finding of fact.
Your objection is noted. It's overruled.
And that's a judicial determination.
I think you be seated.
I love that she didn't answer him.
Go ahead, Mr. Brooks. Please continue with your questioning.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 906.11, I'm not going to allow the witness to answer. It's vague.
There was no objection.
Under 906.11, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this witness.
They're going to keep coming up.
And I determined at that time that they weren't relevant. So next topic,
They're going to
please.
keep coming up.
Under 906.11, sir, please move on to a new topic.
They're going to keep coming in.
For the cross-examination, I will end.
Do you see the state of Wisconsin president in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will bring it to an end.
You don't got to keep doing that, Your Honor. You don't got to keep doing that.
Apparently she
My
does.
responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next
respect
topic.
that.
You respect nothing.
But it's relevant for the jury to know the truth.
No.
They deserve to know the truth.
They only need to
Strike, Your
know.
Honor.
Granted, the jury will disregard
thank
those
you.
last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
not truthful.
All right, under 9.
See, he's talking to his sticky notes or post-its or his guardian angel or demon person. God, it's so infuriating.
906.11, I am now stopping the cross-examination. Any redirect by the state?
Objection to that. And I would like
Noted.
legal finding of fact.
Attorney Opper, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take that under
I'm
advisement.
objecting still because
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that
Oh,
they
for
deserve to know.
gosh sake.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before.
Gosh,
Never-
you
I
shouldn't
haven't
be
seen it.
talking
I
this
can't
much.
rule on it, sir, so let me
I mean,
see it, and I'll
we
take
give
your
it a
objection
exhibit.
under, I'll
It
take
was
the
never
objection
exhibit
under
before.
advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So
Not
how can
about
this be
you.
created now and be made an exhibit?
Yeah.
Go ahead,
I
Attorney
have all
Opper.
the exhibits.
Go ahead, Attorney Opper. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just create exhibits now. I have all the exhibits.
Okay.
This was never in.
Somebody shut him up.
Oh man.
Ooh, people are being slick.
All right, you can stop. Sir, do you recognize what's contained in State's Exhibit 178?
Objection.
Overruled.
Relevancy.
Overruled.
Leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection. Leading.
Overruled. The witness may answer.
I'm still gonna object. How is this?
Mr. Brooks, I ask that you honor
I have all
the
the
ruling that
I
I've
have all the
conveyed.
exhibits though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the.
Here we go. Okay, sorry about that. I had to do a little adjusting. I think he's going to carry on, but, you know, he is so arrogant and so self-assured, which makes it even worse, because he's not any of those. He feels like offended if they don't run everything past him. But you're not an attorney, okay? So let's go on.
Can it just be made an exhibit?
I'll take
just
this
out of
up
the blue?
outside the presence of the jury, but I'm going to allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence, and the state may
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before.
objection
Oh my
is noted. It's
gosh.
overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the
mine.
Ford Escape. This is the video in which that still photo was taken from.
Objection. How did he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection. Leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll find that it's
Still don't know how
relevant.
it's
I'll
obtained.
receive Exhibit 168. Permission to publish is granted. For the record,
It's 178, Your Honor.
no, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that. I would like to make an offer of proof of my appeal.
We'll do that outside the presence of the jury, but I will
Ken,
allow the
it's
state
not
to
your
play it in
turn.
its entirety without audio.
Your Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that's not, that I didn't?
Mr. Brooks, I'll take that up.
He didn't consent to it.
Outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
No, you're mind-boggling.
actually, Your Honor, I changed my mind. I would like to play the audio, please.
This is mind-boggling.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
See, that's how you handle
So we will
things.
play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played?
Oh my God, it looks like a damn
You
fool of
just
it.
set the foundation.
It's relevant. You question
wish he
the
would
officer
shut up.
about it. You
I
question this
question him
detective
about,
about his knowledge.
about the still frame from the video. The video wasn't even in the exhibits that I received.
Oh my gosh.
It actually didn't even receive it.
Mr.
They were
Brooks,
Oh
please
obtained.
stop.
my gosh.
The jury will disregard his statements.
I wish
He's
they-
not
she would
testifying.
send him to the other-
video's playing.
Room. This is so cringy.
So play the sound. I want to hear it now.
Jeez.
I'll address that later.
You just cannot.
We address why it is.
Shut up for a minute. I'm gonna smack him across the face. Look at me, I'm a rapper and an attorney. And a criminal. Gosh. Sorry, I'm having technical difficulties here, guys. Sorry about that.
Go ahead, attorney, after the video is finished playing.
Thank you, sir. Did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled foundational, the witness may answer.
Yes, I
A
did.
lot of
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Popper.
Overruled,
Shut up.
the
Yes.
witness may answer. Sorry.
Yes, I was.
As states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled, the witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video, and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection, I don't consent to being called that name. And yeah,
Noted. Do you have any questions for the witness?
This, when did this video, when was this made a exhibit? Because I don't have it.
Objection. That's not a question for the witness, Your Honor.
That was a question.
Sustained.
When was this
As to the
video
form of
made?
the
Did you
question.
listen? Brooks, good gosh,
When
man.
was this video made an exhibit? That is a question.
He is so mad.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Sustained.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will allow the
When did you see
question
this
to be
exhibit?
asked. With that understanding, you may answer, Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table? It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please?
and faces.
Acknowledge them because
Yes,
I'm
I will.
always the one
Absolutely.
getting admonished.
Every
should
I
be
take that as
admonished.
disrespect too.
Sir, I'm good. Can I do my job? Stinks to
I mean, no, I gotta be honest. I mean, serious, honest to word. I mean, how does he... I know I've asked this a million times, but the jury must be so... I can't even find the word. So aggravated and disgusted by his behavior. Just look at him. And his lack of respect and interrupting and mowing over people. And, well, that was a bit Freudian. But, you know, mentally, you know, not only physically, but mentally. And, you know, nothing's fair. And yet, he just won't acknowledge all the horrible things he's done. It's just so, oh my God, I'm so triggered. Okay, here we go.
directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint,
How about you interrupting? That's
to be respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey. You can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be
Poor
100%
baby.
sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained as to
it was
the
not
form
brought
of
up
the
in your
question
earlier
assumes
testimony.
facts not in evidence.
If you had seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I will see what my
Objection, objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew
Good gosh.
that the video would be made an exhibit?
This helps
morning?
him none. The jury
Objection,
is not going
assumes
to care
facts,
about
not in
that.
evidence.
Sustained as to the form of the question.
This is mind-boggling.
Okay, read those Post-its.
Can you clarify again why you viewed the video this morning?
Objection has been answered.
This is so stupid.
So you're going to sustain everything?
It was
Hell
already
yeah.
answered, sir. Next question, please.
And I'm asking for clarification.
You have dumb questions, that's why.
Next question, please.
I don't got no more questions, man.
All right, thank you.
This is mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. Don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason. Because you asked. I see what you people are trying to do. It's not right.
Oh my
It's not fair.
God.
It's not right.
I'd be livid if I was in the
You
jury.
can have a
having
seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection. I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to
something
make
that
a
I saw?
record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
Gosh, such a...
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would.
inaccurate, Your Honor. Can we have the prior counsel testify to that? Then?
Not
Because
at this time.
yeah,
I
get your
have not
prior
obtained
attorneys in.
that. Right now, that was my first time seeing that as
Oh
an
my
exhibit.
gosh.
Mr.
That's why I
Brooks, I
raised the
presume, and you can correct me if I'm wrong, but you're familiar with that video. Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a
Everything.
finding based upon what I viewed in that video, that there's absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which, it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that. And what relevance, if any, that evidence have, but you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to
What do you mean by
that.
it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can make an offer of proof on that because obviously they marked it as an exhibit.
But with all
So
respect,
go
Your
ahead,
Honor,
Attorney
you're
Hopper.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was how does this, at the last minute, out of the blue, become an exhibit?
Attorney
That
Hopper,
was the
go
issue.
ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection.
aware
He said social
there's
media. He
nothing
didn't
that...
say what it was.
Sir, Stop interrupting. We have to make a record of it. You've
They make the record
interrupted multiple
Gosh.
times. I've been abundantly patient
record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at me. Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor.
I'm gonna take that
And
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him to sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor. And we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record.
Okay. I love Sue Opper. She is fierce. She's fearless. And I don't think anybody has ever been able to talk to Brooks like Sue Opper. I mean, you know, and he hates it. And, you know, he's going to be all butthurt about this. But she is, to me, phenomenal. She's highly intelligent. She knows her objections. And I think that she is protective of her town and the people. She's passionate, but not so passionate that she, you know, folds up. I just think that, and he can't stand it, especially because she's a woman, and it makes me so happy. I can't say enough about her. She just mopped him up. She crushed him. And see, that's the thing. He can't focus on doing anything to save himself because he's got to deal with his hurt feelings. And, oh, she was mean to me and it's unfair. And, you know, he even thinks the judge is unfair. Everybody's unfair to him. When he mowed over all these people tormenting witnesses, many that are victims, thinking he sounds like some slick city lawyer in there for the jury, when I bet with each breathing moment they loathe him more and more. That's how irritated and how much I dislike him. But I love Sue Opper. I can never get enough of her. And I'll definitely be highlighting her a lot more. All right. We shall proceed now.
Being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want...
See? And again, just as Opper stated, but he's too thick in the skull or he's too dumb to get it, is that by leaving those out, the lyrics out, again, it's protecting him. He doesn't realize how many passes they're giving him. He just can't see the forest for the trees, all that good stuff. He just, nope. Okay, you can tell. I'm just like, oh, okay, here we go.
I want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
You deserve so much.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
Yeah, we really don't.
I don't know specifically what you're talking about, sir.
There's a reference made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Look at his body language. Sorry, I have to stop. The reason why I'm saying that is, see, he has totally forgotten his arguments about the niece and the nephew and Detective Casey doing the search of his cell, because now all he can think about is his ego. as fragile as an eggshell. But look at him, his shoulders are all bunched up, and you can tell it's like some kid who's been scolded, and he doesn't like it. And he's totally forgetting about that. Once again, totally forgetting about, or, maybe he just knows he's going to be in prison for 1,000 years. So we might as well just get out and, act like an idiot. And he thinks he's acting all cool and smart. But, he cannot. God, he's such an idiot.
Well, that's not what we're talking about at the moment.
Again.
I made a ruling on an
She's been
exhibit.
laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
Yeah.
I haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No. What I've observed was
listen, please.
Okay,
go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot.
Nobody
That is
said
very
that, sir.
disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what
Her
you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and hee and kee. That they've been doing that the whole time.
Please.
I didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well, we have cameras. That's what the cameras
Oh,
are.
for God's sake. We don't have time for that.
Our attention on what we're here for, and that's
Okay,
this trial.
then I take that
and
as...
do you have anything you want to put on the record?
I'm putting it on the record if I get a chance.
No, you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not... She just said she just made it an exhibit. It was not an exhibit before she made it one.
So do you have some legal basis, sir, for your position? Because I'm not
What do
aware
I
of any.
need legal basis for when she just admitted on the record that she just made this exhibit up right now?
That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't implying that by saying that she didn't pull anything out of her suitcase.
So that's a figure of speech.
Okay, so what is it implying to? What would that be implying to?
As
How would anyone?
Shut up and let her talk.
You're not providing me with any legal basis.
I didn't even finish. You told me that I can make the record.
We're too tired of your records.
To make the record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either.
Because you're not providing me
But how do you know I wouldn't get to that if I
commentary.
finished?
You're not
Dear
providing me
God.
with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need
Please.
to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you open the door to the playing of that video.
We're not talking about
And the
opening
video
those
was
doors.
Oh, yeah.
completely provided
That's exactly
during
what
the
you did.
We're not
discovery.
talking about opening those doors. We're
There's
talking about being fair.
There's
Because
absolutely
if
no
about being fair. The thing is, he opened the door. And I got to go back to Oprah again for a minute. I mean, the way she defended the judge and, she was very passionate about that. You have the right to tell him to sit down. Boy, shut up. I don't think she said shut up, maybe be quiet. But if Oprah were judge, would she have told him to sit down and be quiet? But see, that's what I'm saying. She's like speaking for everybody. And he just can't get past thinking about himself and how he's hurt and how it's not fair. And, he was awful to his mom and is it his grandma or fake grandma and all the women? Oh my gosh. And just everybody in general. And try to act like he's worried about the 7-year-old child. What a liar. Oh, okay.
To you,
Your Honor,
in
with all
terms
due
of
respect,
surprise.
No, you have no
why-
respect. Don't say
if I
that.
had
Right.
done that,
I am going to move on.
if
from
I had
this
done
topic.
that, it would have
Mr.
been
Brooks,
a big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down
I
and
don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me
trial.
contempt.
Mr.
For the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm
Yeah.
asking, what do you mean?
Mr. Brooks, you continue to
That is
come
not,
at me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you.
Liar.
I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
things.
that? Are you asking
I
me
don't
to
need
do
to
that?
ask, I'm telling you.
Big baby. Well,
Thank you.
little baby.
There were 2 other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew.
Listen, he's still talking. He's not even
And
paying
I sustained
attention.
the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these 2 topics? Is my first question.
Okay, why was it an issue with me bringing up
Mr. Brooks, I'm only going to ask you one more
Answer
time.
her question.
I'm saying if I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like,
yes or
I don't
no.
like your tone and the way you're talking to me.
Yeah.
I don't.
Mr.
I don't
Brooks?
appreciate it.
Sit down. I don't care if you don't like my
I'm not
tone.
gonna-
You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too.
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean, stop talking?
I
Shut
need
up.
to make a ruling. Okay,
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's talk to each other
now.
like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
Maybe because she's the judge and you're the criminal. Okay, at that time, alleged criminal. But now we know. We all knew during the thing. He really doesn't understand how to present himself. And I've said this before. I work with young children, kindergarten, first grade age, who have special needs. And we don't do them any... I mean, of course, we love them and treat them the way they're supposed to, but we still expect them to be respectful. It may be a long road teaching them, but I don't know. I don't see where Mama Dawn even attempted to do any of this. I could be wrong. Don't want to pass judgment. I wasn't there. But he just, you know, he just thinks he can come in and just run the whole show, not even know what the hell is going on, but act like he does. But then when it's convenient for him, he says he doesn't understand. He doesn't understand. And then he keeps, you know, it's almost like he's competing. Well, you need to respect me. Well, I never told you to sit down. Well, why the hell would he tell her to sit down? She's the judge. He's the felon. You know, I can say that because he was the felon when even before that happened. This parade attack that he pretends he didn't. Look at him. He's disgusting. Okay. Onward, I feel better now. Okay.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
what was the problem with me asking a
All
question
right,
about
he's
the
not
jail
answered
cell.
my question. We'll move on.
I'm trying to understand.
Yep.
If I
Yeah.
don't
We're gonna
understand,
Yeah, we're
how
done.
do I know?
Recess, 15 minutes
How do
from
I
now.
know
Thank
what
you,
I'm supposed to
everyone.
answer if I don't understand?
Yeah, you just don't.
And I don't agree to a stop.
Estoppel. Damn estoppel. Okay, looks like they're back from their lunch. He's going to get his little basic duty boxes in order and set up his Bible. You can tell he's a wounded little boy. Oh, I guess they don't have the sound on. Look at him. Yeah, he just got mopped and crushed and stopped by Opper. He is a joke. And it's amazing that many of us are still watching him, but I think it's just because we are here to witness the idiocy.
The record in State versus Brooks
Somebody like
appearances are as they were before.
I think the audience can try.
Yeah, let's do that. All right, let me do that again. We are back on the record. State versus Brooks appearances are as they were before.
I don't consent to being called that name for the record.
But asswipe.
Are there any issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
No, Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has. So I believe we are good on that.
I had one question
Oh, sure.
about Exhibit 89, and I don't know if I missed in my notes.
Okay.
What do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a certified bail form.
No, I'm asking.
Oh.
I'm asking Mr. Brooks.
Oh, sorry.
That was the second of the two bail bonds. Do you have a recollection of whether it was received?
I don't.
All right, and then
I
what
know
was
I objected to it.
Of course you
I know
did.
you objected when it was, I think, displayed for the witness who then testified about it. I'll receive it and also advise the jury. Were there any other exhibits? I have one other issue on evidence and exhibits as well, but are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
I don't believe so. I know at one point someone caught that we moved, it was either Exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
So maybe just
I
had a
think you
misspeak.
misspoke.
Yeah.
You have any recollection of that, sir?
Recollection of what?
See, because he's being a big baby, he's doing just like a kid would do, whether it be a preschooler or middle schooler, high schooler, or a 41-year-old felon. He's going to tune him out. His head's going to go up. I'm going to be drinking a lot more Sprite here, right? Be studying his Post-its up on the ceiling. I don't know, whatever notes he has up there, if he does, they have not served him well at all. But he's going to, like, tune everything out because he's hurt. They have hurt him, that poor fellow. And, yeah, my words are getting a little more cursy here, through here. I'm trying to work on my cursing because I typically don't do it, but when I get really aggravated, I do. And, well, I'm comfortable at home and things like that, but I mean, I work with kids, so I can't, well, I did have to get my school voice prepared again because before the kids came back, well, a lot of us do because we have to curse. But I think when I get really, I do curse. So I'm trying to do better with that. But anyhow, just look at him though. I'm just saying he's not going to be responsive. He's going to be all, you know, he's just going to like, he's not going to participate. And that is one thing I have to say I love about Judge Darrow is that she can be there 1 minute, and I've had some criticisms of her, not many. I guess the biggest ones are I wouldn't have asked him the same question as many times. Maybe you have to do that. I don't know. I couldn't do it, and I would have probably sent him to the timeout room a lot more. But that's, hey, you know, that's me not being experienced in any of this stuff. But I love how they can be in, you know, something, you know, maybe arguing back and forth and comes back and she's just like, okay. So, you know, she goes on about like nothing happened, or like even if he's giving her hell when the jury's coming in, she's always smiling at the jury. Now that is a rare skill not many of us possess. I've been able to pull it off a few times, believe it or not. But yeah, she just goes back to, and I think that's the other thing he doesn't like. Like, instead of, you know, he's probably wanting her to say, oh, what's wrong? Are you okay? Oh, I'm so sorry. This wasn't fair to you, you poor thing. Please. He makes me ill. Okay. Just had to say that. Here we go.
Related to what the state just put on the record. Do you know what was that? What witness that was?
That was Detective Casey.
Look at that.
They might be whispering about him right now. Look at him. He's a broken little boy. Bless his heart.
175 was the screenshot taken from the video. I know I have a note that it was received and published. And you believe I may have just referenced it by the wrong name?
I thought it was 178. I thought you referenced it by the wrong number. So it was either 175. 175 was referenced as 165, or 178 was referenced as 168.
What is 170? I know that 175 is what I just said.
Correct.
What was 178?
178 was the video.
Oh, that was the most recent one. Okay. What's the request then as it relates to when the jury comes back in?
Your Honor, I've just, there's two different ways to do this. I can put on the record, I have the exhibit numbers, and I can just put on the record just to verify that these exhibits have all been offered and admitted into evidence, and the court's agreeing, because we've just agreed that those are, your records are the same as my records, or we can clarify just if there was some confusion about exhibits 175 and 178 that were shown to the jury this morning. Those 175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
All right, sir, do you have any position on how I address this in front of the jury?
Yeah, I'm objected to him being admitted at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but the fact that I've already ruled on the admissibility is not something I'm going to revisit.
What I gotta say.
Hold on, that door is. All right, it's sometimes that door upstairs malfunctions, and all right, I didn't hear the last part of what you said.
What I have to say about anything definitely doesn't matter.
I take huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt. You try to debate the topic again and again. You make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes.
Mm-hmm.
I mean, just previous to the break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey.
But he pouted, decided to pout.
Multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly.
That's right.
Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings because frankly I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on.
Look at him. I'll tell you what else he makes me think of. Like, I'm thinking of a dog I used to have. An older dog, big dog. And like if it didn't want medicine, I don't know what it would turn its head and it did not want to make eye contact. But my dog was much nicer, much smarter than this fool. And look at the bailiff looking at him like, what a freaking idiot. He should be ashamed of himself. I mean, if Mama Dawn, be ashamed. I bet you she's glad he's in prison. I mean, I would be. All right, here we go. Let's just look at him continue on.
Now, with respect to, I want to also address
he started to speak.
Exhibits. And the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was, frankly, to assist the court and my clerk in keeping track. Most trials, the normal course of action is, as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal, we're not quite there yet, that as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement unless a judge orders it that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit. There was nothing improper about what the state did with Exhibit 178. And I want to make that record very, very clear. as Attorney Opper stated, trials are fluid. Things happen. Parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other acts evidence with Erica Patterson.
Okay, I know. I told you I will talk a lot through some of these if I get really edgy. But look at him. She's explaining all these things they have done to help him, but he is going to just tune her out, you know, because he really doesn't want to improve himself. He thinks he's improved. I think he thinks he's the best he can be. He doesn't want to hear from anyone else because he believes he knows everything, even though he'll say, I don't understand, and he just, that disrespect, I really do just want to smack him across the face every time I see him. Oh my God, especially when he's acting like this. Okay.
And I frankly kept it out, despite your questions.
Yeah, he made it harder for her. You tell him. Oops, bumped it.
So, with that, I want to bring the jury back out.
Oh my gosh.
I will ask the state. I'll simply just ask the state, are there any anything additional the state's offering by way of testimony or exhibits? You can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony. Before I bring the jury out, there's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
So is that addressing subject matter jurisdiction?
Oh, shut the hell up.
When would that be proven for the record?
Sir, please don't interrupt me. I need to focus on what
I'm not interrupting you. I'm just asking a question.
All right. I'm not going to be addressing
She's trying to focus on the computer.
Don't interrupt me right now. I'm trying to do something on my computer.
What did you proven on the record?
I gotta stop for a minute. Ugh. He just, no sense of anything around him but himself. I have no idea why he would possibly think so highly of himself, of all the hideous things he's done. He is a true narcissist, among many other things. That's right. Study your Post-its. Hopefully you get to read a good one here.
I feel it's important at this time to at least give you the advisement pursuant to Special Material 28. It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed, not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not.
What's the significance of that?
So that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent?
That's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then. We can kind of tidy up the record and then we'll break for lunch.
Judge, may I remove that exhibit, please? All right.
I think they're right there. So
What is he so put out for?
Jury already coming out.
When did that ever stop you?
So go ahead and sit it back down. Thank you.
Don't tell them what to do.
Subject matter jurisdiction still hasn't been proven for the record, Your Honor.
Oh yeah, he's talking about them, and now he's going to say it as they come in.
At some point.
No. We just need to get you in prison. Oh, she's not giving him he's really upset because she's not giving him enough attention.
thank you, everyone. Please be seated. All right, then I'll turn to the state. Any additional evidence at this time?
Oh, he rolled his eyes
Additional
inside.
evidence, Your Honor, may we make a record of the exhibits?
Disgusting.
Go ahead, please.
Your Honor, we believe that the court has admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number, or there are, it's 1 through 78, 1 through 178, but there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most recent testimony?
The most recent testimony, with Detective Casey, we moved 177 and 178 and 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over, exhibits 88, 89, 150, 151, 177, and 178. If I didn't receive them during the testimony, I'm receiving them now.
And 175, which was the still photo.
Thank you, sorry, I had to scribble on my pad, and 175.
And 13 and 14. Those are the outliers, I apologize.
I believe those were received as well, but if I didn't
Objection, I
state
think
it.
they was already received.
I appreciate that, I just want to be thorough for the record. 13 and 14 were received as well. Do you have any additional witnesses to call at this time?
No, Your Honor, at this time the state rests.
All right, thank you. All right, then at this time we are going to break for the lunch hour. I am going to have everyone come back at 1:30. It's a little bit longer, at least that's what I want to do for the lunch hour today. So all rise for the jury. Thank you. Be seated. Mr. Brooks, anything from you at this time, given the state is now rested?
What you mean?
What you mean?
I'm asking you the question. Do you have
So
any
rude.
requests at this time now that the state has rested?
What request and pertaining to what exactly?
I'll ask the question one more time. Do you have any requests to make at this time now that the state has rested?
I don't understand what you mean by that. That's why I'm trying to get clarification.
I'm not going to give you legal advice. I'm simply asking the question. Do you have any requests to make at this time now that the state has rested?
I don't know what I'm supposed to say to that. I don't understand.
How can he say that when he gets up there and has requests about his, as I call them, idiot complaint forms and his subject matter jurisdiction? See, I mean, he's dumb, but there are some ways he's playing dumb on this one. He's just trying to be obstinate and I don't know what you mean. And I don't know. I wouldn't ask as many times as she does, but maybe there's a certain amount of time you have to, a certain amount of times you have to ask them. Ask them. He got butt hurt.
What would that be pertaining to?
I can't give you legal advice, sir. I'm just asking the question to make a record. I'll ask you one more time. Do you have any requests to make now that the state is rested?
I don't understand.
All right, the other thing I want to do when the jury comes back out is you will recall I read instruction 101 at the very end of the preliminary jury instructions that just has to do with opening statements. I will read that with the caveat. It will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statement is not evidence. So I'll read that. I think it's appropriate given that Mr. Brooks deferred his opening statement until the start of his case. With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to go at 1:30 with your opening statement.
I got a question.
Oh, man.
Do I get to present exhibits and stuff like that too and admit them into evidence?
Oh, for the love.
Say, at what point are we talking about? Do you want to use exhibits that have been received during your opening?
Oh.
Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence.
Are you kidding me?
Which is a question I asked previously.
Do you believe the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they documents from the discovery that you have?
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer
Give me
for
an
evidence.
example, please.
I just did. I said I have filings that I want to offer into evidence.
Oh,
That's too
Lord.
general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings. Everything
Which
that I filed.
filing, sir?
Every one of them.
Well, they have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm
filings.
being general based on what I've seen thus far. So, are you talking about during your opening statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said
Clearly as
filings
mud.
that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I filed a number of documents. I think that's on the
Well,
record
without
that I
knowing what
filed.
you're referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They will only be relevant to, obviously, the matter.
What matter?
They wouldn't
Sir,
be relevant to anything
I
else.
can't answer that anymore. We're going to take our lunch break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
So I'm not allowed to offer anything in the evidence?
For the record, I never said that.
There once again. And see? He's talking about his filings, all his stupid paperwork. That's not going to be any exhibit. Oh my goodness. I just, I don't know. Sometimes he just floors me.